And the reason why I think it's important to think about litigation is that it can be a useful hammer. And there are a lot of preservation groups all around the country that do wonderful work in terms of education and advocacy, but if you can't enforce the law, the rule of law, the historic preservation law that they're fighting about, then your efforts are largely going to be wasted. And I think it's because of our respect for the rule of law that the Historic Charleston Foundation and the Preservation Society that we decided to litigate against the city of Charleston to stop this proposed development, which in our belief rudely tampered with our skyline and failed to protect, as the 1974 preservation plan required, failed to respect adjacent historic buildings. Now, the developer made the argument throughout the approval process that there were all these tall buildings around the square, even the church steeples, which in Charleston have a special place. So disingenuous about that argument, and Winslow already mentioned this, was that the taller buildings that the developer wanted to use as appropriate examples were built before the historic preservation law was adopted. And the preservation law didn't use the word adjacent historic buildings, it just used the word adjacent buildings. And that's why we have to keep coming back to this statement of policy about the importance of our skyline and the need to protect not just historic buildings, but also the context. And that's really key too. And that's critical in order to not only to gain National Register listing or National Landmark status, but also to maintain it. So it's not just the buildings having the National Register listing are important. The context around those buildings is important too. And the context, we believe in Charleston, deserves to be protected. And it's our belief that our rule of law required that. And I encourage you in New Bern, if another new project comes along that you believe is an inappropriate height, is to fight this tooth and nail, because what will happen in Charleston if this hotel is built, this is the argument that developers have made, is that this new building in red will be the appropriate benchmark for the next one. And that's exactly what is starting to happen. Winslow had this great slide. Yeah. These are several of the proposed new developments around the square. The very first thing they will do is say, well, we just approved this one, so this new height must be okay for here. We should be allowed the same height here. And then we will end up with the parade ground that was once surrounded by low-scale buildings that is now, rimmed around with these tall and congruous buildings. Next thing that happens is that developer seeks conceptual approval for the design of the hotel. Well, the design, and in our Board of Architectural Review, the first stage of review is conceptual review, looks at height, scale, and mass of the building. And Winslow is exactly right. All you heard is this economic argument, how great it would be for job creation, people could get married there, it would be a great anchor. It's all irrelevant. And if you're attending meetings like this at your own preservation groups, at the preliminary level of review, I would encourage you to object to the introduction of that evidence. It has nothing to do with height, scale, or mass. What happened in Charleston with this hotel is that the concept that was presented to VAR was presented based on the assumption that the city would approve a height variance, even though no height variance had been allowed. And so at the time of design, anything exceeding that height would have been illegal. Our Board of Architectural Review approved a building that was illegal under current height standards. The character of the district will not be diminished. And this is why I mentioned earlier that it's important for you to be hyper-vigilant about protecting the context of New Bern in order to maintain your National Register listing.